Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Where am I today? Oh, hey, check it out. North Idaho Arms. That's right. Washington Renegade here doing Idaho Patriot work. Hey, listen, we're going to talk about the intersection between our Second Amendment rights and federal law that prohibits cannabis users from ever having access to firearms. Now, we have talked about this case before. It's a case of United States v. Daniels, and it's a case that was sitting on the front steps of the United States Supreme Court when the Rahimi ruling came out. The United States Supreme Court decided to send it back to the Fifth Circuit, who had already found the law unconstitutional, to have them take another look at it. Well, guess what? The Fifth Circuit has reaffirmed their decision, and this is yet another death nail in a law that, candidly, his death is long overdue. So today, let's spend a few minutes and let's talk about another major loss for this federal gun law. Yeah, the video is sponsored by Taylor Freelance. Okay, you guys realize that YouTube is gonna just absolutely squish this video, right? All right, here we go. Hey everybody, this video is brought to us by our good friends at Taylor Freelance. We would normally start showing all sorts of cool stuff that they make here, but according to the new YouTube policies, we will be demonetized if we do so. So you know the stuff they're making has got to be pretty good. Hey, listen, here's the deal. American made, right there in Bellingham, Washington. They won't make your firearm, but they will make your firearm a lot better. So for more information, go ahead and click on my partner page right there. And once you're there, click on the Taylor Freelance link to see all the fantastic items that they can bring to you. For more information, go to my partner page. Okay, America, we've talked about this case before. It is the case of United States v. Daniels, but in reality, what we're talking about is a challenge to 18 United States Code Section 922G3, which of course is the federal prohibition against cannabis users from having access to firearms. Now, if we go back down memory lane, we will remember that just a couple of years ago, the Fifth Circuit found that this law, as it applied to Mr. Daniels, was in fact unconstitutional, that there was no historical tradition of a blanket ban on firearms merely because a person used a controlled substance, and found the law unconstitutional as it applied to Mr. Daniels. Now, of course, the United States government crapped their pants, appealed it to the United States Supreme Court, and while the case was pending review, the court issued its ruling in United States v. Rahimi, and then GVR granted, vacated, and remanded the case back down to the Fifth Circuit. Why anyone in the Supreme Court thought that the Rahimi decision was going to change the Fifth Circuit's opinion is anyone's guess. And to nobody's surprise, the Fifth Circuit has absolutely, positively reaffirmed its previous ruling and found 18 United States Code Section 922G3 still unconstitutional. As a matter of fact, in reaffirming their decision, the Fifth Circuit has specifically ruled Daniels' 922G3 conviction is inconsistent with our history and tradition of gun regulation. We do not invalidate the statute in all of its applications, nor do we decide that Section 922G3 could never cover the conduct of which Daniels stands accused. But the application of Section 922G3 must accord with our nation's history of firearms regulations, and disarming individuals solely for their prior, occasional, or habitual marijuana use does not. So I want you to understand, America, that this is an as-applied challenge, which means the Fifth Circuit has found, again, that the law as it applies to Mr. Daniels' set of facts is unconstitutional in its application. Now, although the ruling is the same, the reasoning that the Fifth Circuit used was ever so slightly different than their previous ruling, because in the interim, as you may recall, there was also the case of United States v. Connolly, a case that we also covered by the Fifth Circuit, which dealt with this exact same issue. And so therefore, if you want to really get geeky under the rule of orderliness, then Connolly is the controlling authority, and so the Fifth Circuit used the same reasoning in Connolly to get to the same conclusion that it had already previously reached the first go-around on Daniels. But here's the important thing you see for Mr. Daniels, because his conviction, his criminal conviction for being an habitual marijuana user in possession of a firearm will be overturned and vacated. And the reason is, and this is the quickest way to get a criminal conviction overturned, is all you have to do is give the juries bad jury instructions. And the low threshold in which the United States government believed they had to prove, that is, that Mr. Daniels at some point, sometime, somewhere had used cannabis and was also in possession of a firearm, that was sufficient proof beyond a reasonable doubt. But the court found quite differently. As a matter of fact, in speaking to the deficiencies of the jury instructions that were given to the Daniels jury and how it watered down the government's burden of proof, the Fifth Circuit ruled, in other words, the government's burden of proof was too low, as it was not required to convince a jury that Daniels was presently or even regularly intoxicated at the same time of arrest. Because of his instructional error, Section 922G3 must thus again be held unconstitutional as applied to Daniels. So, is this a big ruling? It's a big ruling. Is it an unexpected ruling? No, it was not an unexpected ruling at all. We already knew how the Fifth Circuit saw this issue once before. We knew that Rahimi was not going to change anything about it, and the Fifth Circuit has reached an exact same result, although they used mildly different analysis to get there. The important news is that for millions of Americans who may be using either cannabis recreationally, or for those in particular who are using cannabis for a medicinal need, the freedom from not having to choose between making health decisions or defending your life, those days may be coming to an end. It is my belief that 18 United States Code Section 922G3 is living its last final days of existence. Okay, the case once again is United States v. Daniels. We're going to link it up down below so that you guys can geek out on the ruling for yourself. Maybe you got some questions about this or something else related to our Second Amendment rights. If you guys do, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video that we should be doing around here, all you got to do is click on that link right there and let us know. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From beautiful North Idaho Arms here in Post Falls, Idaho, hey, be a rebel and stay safe.